The last section that we need to discuss is the inadvertent disclosure. And we talk about inadvertent disclosure in civil litigation, especially civil litigation too. So a lot of you are familiar with this concept, but inadvertent disclosure of privileged information. It is not something we want to happen, but sometimes when we are dealing with multiple documents, sometimes privileged information manages to be disclosed to the other side. It can also happen when sometimes we just get a little careless. We include somebody on an email that we didn't mean to include. We attach the wrong attachment to an email. We put the wrong letter in an envelope. So there's a lot of ways it can happen. And our job is to avoid that as much as we can. But if it does happen, what you want to always make sure that you do, whether you think you were on the sending side or the receiving side, is to tell your attorney immediately, because it can be fixed. However, the more time that passes, it becomes much more difficult to fix it, and it could eventually actually harm your client's case. So, things like this do happen. We don't want it to. We want to take steps to avoid it. But if you ever are aware of it, whether you're on the sending side or receiving side, let the attorney know immediately. And so the rules that deal with this issue, the main rule is Rule of Professional Conduct 4.4 subpart B, which requires the receiving attorney who knows or reasonably should know the information is privileged to notify the sender. So if you receive documents in response to doc requests and you see information in there that either is marked privilege, or you just identify it as being either protected by attorney-client or work product privilege, close it up. Let the attorney know, let them know immediately. Then what the attorney should do is notify the sender that privilege was sent to them. And in most cases, what should happen is the sender is going to say something like destroy it, send it back, delete it, something along those lines. And that's what the receiving attorney is going to do, and the problem is solved. There are going to be cases, though, where there can be, for lack of a better word, good faith dispute over what the receiving attorney should do. Now, the federal rules of civil procedure require parties to hold a discovery conference early in the litigation process. And one of the things that they're specifically supposed to address is how to deal with inadvertent disclosure. So a lot of times, if you're handling cases in federal court, you'll have the clawback provisions, which allow the party, once they actually send the information and realize what has happened, they can invoke this clawback, which literally is just clawing that information back, and the other side willingly returns it to them or deletes it or whatever, so they don't have it anymore. Pennsylvania rules of civil procedure. So in our state court, we don't have any rules that specifically address it. So it's a little more up in the air, although we still have the ethical obligation, if we're on the receiving end, to notify the sending attorney. So again, the best practice is to always notify your attorney as soon as you are aware of this particular situation. What Rule 4.4 does not address is what happens after that. So say the receiving attorney notifies the sending attorney, and the sending attorney says destroy it, and the receiving attorney says I don't want to, I'm going to use it. What happens at that point? And so for that, because the rules specifically do not address it, we look at case law. And the case that deals with this, the state court case that deals with this, is the Carbis Walker case. And this case is in the materials. And this is the test that you're going to apply to the situation in the discussion board. You do not need to read the entire Carbis Walker case. I'm actually giving you the information here, so technically you don't even have to read it at all. So good for you if you're listening to this. You're saving yourself some work. But the Carbis Walker case developed a 5-factor test, and it is a balancing test. So what you would be doing in any given situation where there is a dispute over what should happen with this privileged information. Has privilege been waived? Can the receiving party use it? or has it not been waived and the sending party gets it back and the receiving party cannot use it. So the 5-factor test. So the first factor, reasonableness of the precautions taken to prevent inadvertent disclosure. So this is what the sending attorney does. So what procedures, processes, precautions are in place to try to prevent the inadvertent disclosure? So like the most common one we see is that disclaimer at the end of our emails, which is not a bad thing to have, but in and of itself, probably not going to be enough by itself. So what precautions were taken? Were the documents marked privilege? Were they, was there a system in place to have a double check of all the documents before they were sent in response to a request? Those are the types of things they're going to be looking at. So that is the first factor. The second factor is the number of inadvertent disclosures. So literally how many disclosures were there? So say you're sending 500 pages of documents to a opposing party and there's one disclosure in there. Okay. That's the type of thing that happens. But if you're sending 500 pages of documents and you have 50 pages with disclosures, that doesn't seem to bode too well for that sending attorney. It seems like there clearly were not reasonable precautions in place and that these should have been caught. It wasn't like the needle in a haystack. It was like a lot of needles in a very small haystack, and it should have been found. The extent of the disclosures. Now, the extent of the disclosures is the one that people tend to get confused. That is actually looking at the content that was disclosed. So the number of disclosures is looking at literally how many disclosures were there, how many documents, how many pieces of information was disclosed. The extent's looking at the content, and the content, really, when you're looking at that, you're looking at, was it a complete disclosure? Did it disclose a huge amount of information? Was it just a little bit of information? Because sometimes how the cases have been decided is the more complete the disclosure, the more likely it is considered a waiver of privilege and the receiving side can use it. That the more limited the disclosure, the easier it is to pull it back and it would not be considered a waiver. So that one, you just have to see what kind of information was shared. The fourth factor is really the factor that courts seem to, by their own admission, put a lot of weight on the fourth factor, and that is any delay and the measures taken to rectify the disclosure. So once the sending party realizes that there had been a disclosure, what do they do? And the quicker they take action to try to get the information back, this is going to be heavily weighed in their favor. If they delay in acting to try to get the information back, if they are ambivalent about trying to get the information back, that is going to that's going to work against them. Now, the one thing about the delay, when we're talking about any delay, it is you're looking at the time from when the sender learned about the disclosure until the time the sender took action. Because what can happen is you can have a disclosure, not be aware of it, and then all of a sudden those documents are offered an motion for summary judgment or in a deposition or at trial. And so it's not reasonable for the attorney to be aware that this happened until maybe months later. That's not the time frame you're looking at here. You are looking at the time frame from when the attorney found out or reasonably should have known there was a disclosure until the time the attorney takes action. So if the disclosure happened 3 months ago and the attorney discovers it today and tomorrow contacts the receiving attorney and says, I want the information back, do not use it as privilege, that's a minimal delay. That's a delay of 1 day from the day they found out today until tomorrow when they actually take action. That would actually work in that attorney's favor. And so that sometimes gets confusing when people are applying this test to actual facts. And also keep in mind what should happen when the receiving attorney finds out, or reasonably should have known they received privileged information. Under the rules, they're supposed to notify the sending attorney. And then as soon as that sending attorney finds out, they make it known to, that they want the information back. And so ideally that's how it works, but sometimes people aren't doing what they're supposed to be doing. And then the last factor is whether the overriding interest of justice would or would not be served by relieving the party of its errors. So basically you're just looking at kind of a fairness factor, which you can include a lot of different potential information in there. So, you're looking at, is it more fair to, based on the particular circumstances, to allow the privileged information to be used? Is it more fair to have it maintain its privileged status? And so those are the factors that you're going to be dealing with. So you're going to take these 5 factors and you're going to apply them to the case in the discussion board. And so when you read the case that's in the discussion board, you're really looking at the facts of that case. And this is not a typical inadvertent disclosure case, because there's potentially some wrongdoing on the part of the receiving attorney. We don't usually have that. But I think that this case has really interesting facts, and it's an interesting one to see what happened. It's also kind of disappointing that it would happen, but there's a lot there that you can discuss in the discussion board. But whatever you do end up discussing in the discussion board, make sure that you understand these 5 factors and you can apply them, and you apply them correctly. This, I will tell you, that you will have a situation on the test and on the final as well, where you're going to have to apply the Carbis-Walker test. So you're going to have to know the 5 factors, and you're going to have to understand them enough to apply them to a particular situation and reach a conclusion. So the discussion board is your opportunity to practice that and also see how other people do it, which can help you understand how to do it better as well. So that is the information that we would have covered in class on Tuesday night had we had class. Again, I apologize for the typos in the PowerPoint and for the dogs barking in the background. I had to put this together pretty hastily so I could get it up online for you in enough time. If you have any questions, please let me know. But otherwise, I should see you next week.